What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta. I'm a lawyer in central Minnesota, and I own my own law firm. That is Rekieta Law. So if you're ever in trouble in Minnesota, look me up. For now, though, today, tonight, whenever you're watching this, I am not your lawyer. I am your tour guide. I am your liaison to the law in this in this rather interesting case brought by one Stephanie Clifford, aka Stormy Daniels, aka Peggy Peterson, against Donald J. Trump, aka David Dennison, and Essential Consultants LLC, a Delaware LLC, and John Doe's or Jane Doe's 1 through 10 inclusive. So this was just filed March 6th. That is, as of this recording, just barely yesterday. This was filed in Los Angeles County. This is a California case. I am not a California attorney. I do not offer any of this commentary as legal advice, of course. Watch this merely for your own education, entertainment, and depending on your disposition, perhaps edification. So, if you're not familiar with the channel, if this is a new video for you, I go through legal documents and I explain what is going on, what my thoughts are on the merits of the claims involved, the quality of the assertions presented, and all sorts of other stuff. And we tend to go through these things line by line, full document, so it is a little bit of a long video. So I apologize, not really in advance for that. If you want 5 things you need to know about this video, I have not done those types of videos yet. And I'm sure you can find them, but you're not going to get any actual explanation or insight to this. And you're usually going to get some sort of slant. So we're going to go through the whole document, and we are going to see what this looks like. And I will offer some commentary and insight that I have spent lots of time and money acquiring. And you are free to agree or disagree with it as you will. But we'll see where it takes us. We'll see where the document takes us. I have pre-read this document and most of the agreement that follows, and we're going to go through all of it. It is a total of 28 pages via PDF. So buckle in. The other thing I do is drink scotch because, well, sometimes you need a little scotch. And tonight I am having one of my personal favorites, the Bowmore. There it is. Bowmore 15-year Darkest. It's a fantastic scotch. Pretty reasonable for the price too, or for pretty reasonably priced, I should say. You know, you can get a lot more expensive scotches that taste like garbage compared to this. So. All right. Well, let's get started, shall we? So this is an interesting little case. If you're not familiar with the background story, Donald Trump is president. Yes, if you're just waking up, that has happened. Donald Trump is president, and Stormy Daniels is a former porn star whose legal name, I guess, is Stephanie Clifford, and she is referred to in this document, allegedly, as Peggy Peterson. So, the whole idea is that Stormy Daniels and Donald Trump have had some sort of relationship. It is alleged to be a sexual relationship. And the allegation is that Michael Cohen, who is Donald Trump's personal attorney, during the campaign, paid Stormy Daniels $130,000 for her to remain quiet and not talk about really any details of their relationship or any other details about Mr. Trump, President Trump, whatever you want to call him. Or any other details about him or his family at all. So that's the backstory. That's where we are. And now, okay. So the next part, Michael Cohen acknowledged the existence of a non-disclosure agreement. And now Stormy Daniels, through her attorney, has said that Michael Cohen's disclosure of the existence of the non-disclosure agreement amounted to a breach of the non-disclosure agreement. And that said breach provides her with the opportunity to then say whatever she wants and talk about this, because I'm sure she's looking at a decent chunk of income for that story. But, that's my own personal opinion, is that her telling the story would net significant profit to her, and that would be a good business decision if this little problematic non-disclosure agreement doesn't step in the way. So let's go through it, and I will talk as we go. All right. So plaintiff Stephanie Clifford, a.k.a. Stormy Daniels, a.k.a. Peggy Peterson, who will from now on be referred to as Miss Clifford or plaintiff, hereby alleges the following. Plaintiff, Miss Clifford, an individual, is a resident of the state of Texas. Defendant Donald J. Trump, a.k.a. David Dennison, Mr. Trump, an individual, is a resident of the District of Columbia, among other places. Defendant Essential Consultants, LLC, henceforth known as EC, is a Delaware limited liability company formed on October 17th, 2016. Mr. Trump and EC together shall be referred to hereafter as defendants. The true names and capacities of the defendants does 1 through 10 inclusive, whether individual, plural, corporate, partnership, associate, or otherwise, are not known to plaintiff, who therefore sues said defendants by such fictitious names. Plaintiff will seek leave of the court to amend this complaint to show the true names and capacities of defendant does 1 through 10 inclusive when the same have been ascertained. So what the plaintiff intends to do is request something called discovery. If you're not familiar with the legal process, going through the court system, you do a thing called discovery, where each side is required to, or is allowed to, ask the other side for information that would be both beneficial and detrimental to their case. And there's a bunch of required discovery that happens, but otherwise they can ask for very specific things. For example, all emails between Mr. Trump and someone else in regards to any one of the three aliases, Stephanie Clifford, Stormy Daniels, or Peggy Peterson, between the years of 2014 and 2016 or something like that. They can request that type of discovery, and then the courts would be able to enforce disclosure of all of those documents, at least in theory. So then what they plan to do is discover if there's anyone else involved beyond Trump, Cohen, and Essential Consultants LLC, like perhaps if there are other people involved with the LLC. And they would then amend this complaint and name them when their names are discovered in discovery. So that's the whole idea with that line there. Plaintiff is also informed and believe, and thereon alleges, that does 1 to 10 were the agents, principals, and or alter egos of defendants at all times herein relevant, and that they are therefore liable for the acts and omissions of defendants. Jurisdiction and venue. Jurisdiction for this matter properly lies with this court because plaintiff seeks declaratory relief, and the district court, County Court of Los Angeles is able to provide declaratory relief. Venue is appropriate in the County of Los Angeles, and this court has personal jurisdiction over defendants in each of them by reason of the fact that, among other things, the alleged agreement that is at issue in this complaint was purportedly made and negotiated, at least in substantial part, in the County of Los Angeles, and B, many of the events giving rise to this action arose in California, including within the County of Los Angeles. Now, maybe that's true. I don't actually know. It doesn't seem to be the case based on my read, but maybe you guys will think of something different. For what it's worth, Miss Clifford, Stephanie Clifford, had this document signed and notarized in Texas, where she resides. Mr. Trump lives in D.C. and New York primarily, or I guess he would have ties to Mar-a-Lago. I don't know that he would have any specific ties that would bring him to Los Angeles County. She's going to allege that there was a meeting right here with Mr. Trump in a bungalow at the Beverly Hills Hotel within Los Angeles County. I don't know that that is sufficient or sufficiently provable to give jurisdiction, but we'll just give her the benefit of the doubt and say that it does for now. But this is probably one of the grounds they're immediately going to attack, is that in relation to this transaction, it does not look like it belongs in Los Angeles. It looks like it would belong in Texas, where the document was signed and notarized, or perhaps it would belong in Washington, D.C., or New York City, in New York, where the president lives and maintains a residence, or maybe in Florida, where he maintains a place at the Mar-a-Lago. But I don't know. I'm not familiar enough with Trump's properties. Maybe he has sufficient property in Los Angeles to bring it to Los Angeles County. But if he does not, I think that's a place where they'll attack jurisdiction immediately. But let's assume jurisdiction is probably valid. Trump does a lot of business around the country, so it's reasonable to suggest that he would have some sufficient ties to Los Angeles County. In 2015, Mr. Trump announced his candidacy for president of the United States. Oh, I skipped one. Sorry. Ms. Clifford began an intimate relationship with Mr. Trump in the summer of 2006 in Lake Tahoe and continued her relationship with Mr. Trump well into the year 2007. This relationship included, among other things, at least one meeting with Mr. Trump in a bungalow at the Beverly Hills Hotel located within Los Angeles County. And this is another possible problem. It is possible that any such transaction that took place between Mr. Trump and Ms. Clifford would be time barred by statute, which would be beyond the statute of limitations, seeing as how these events were 11 years ago. So that's another potential point. Now, what Ms. Clifford would argue is that the document in question was not executed 11 years ago, but it was executed in 2016, and the document is at issue. Possibly that will work. But again, if Trump's ties to Los Angeles are too far removed, then they could still win on a jurisdictional dismissal. But we'll see. Okay, in 2015, Mr. Trump announced his candidacy for president of the United States. On July 19, 2016, Mr. Trump surprised everybody, securing the Republican Party nomination for president. On October 7, 2016, the Washington Post published a video, now infamously known as the Access Hollywood tape, depicting Mr. Trump making lewd remarks about women. In it, Mr. Trump described his attempt to seduce a married woman, how he may start kissing a woman that he and his companion were about to meet. He then added, "I don't even wait, and when you're a star, they let you do it. You can do anything." This statement does not belong in this complaint. Not at all. That is a prejudicial statement in regards to this dispute. It doesn't offer any probative value, in my opinion. I don't believe it belongs. Now, what Ms. Daniels goes on to claim, or Ms. Clifford goes on to claim, is that the Access Hollywood tape sparked the women coming forward to speak out against Mr. Trump. I don't think that including the details of what he said or that this tape is necessarily useful information, but a judge may disagree. Within days of the publication of the Access Hollywood tape, several women came forward publicly to tell their personal stories about their sexual encounters with Mr. Trump. See, Ms. Clifford does not need to justify her desire to share intimate details about Mr. Trump with the actions of other people. That's why these are two suspect lines to me. To me, a judge could always disagree, and California very well likely will. Around this time, Ms. Clifford likewise sought to share details concerning her relationship and encounters with Mr. Trump with various media outlets. I bet she did. Probably looked rather profitable. As a result of Ms. Clifford's efforts aimed at publicly disclosing her story and her communications with various media outlets, Ms. Clifford's plan came to the attention of Mr. Trump and his campaign, including Mr. Michael Cohen, an attorney licensed in the state of New York. Mr. Cohen worked as the top attorney at the Trump Organization from 2007 until after the election and presently serves as Mr. Trump's personal attorney. He's also generally referred to as Mr. Trump's fixer. After discovering Miss Clifford's plans, Mr. Trump, with the assistance of his attorney, Mr. Cohen, aggressively sought to silence Miss Clifford as part of an effort to avoid her telling the truth, thus helping to ensure he won the presidential election. This is worded a little bit strong because they're not asking her to do anything illegal as far as we can tell. They're asking her not to disclose something to the media. And this is an important thing to remember because the way this document is worded sounds very nefarious, but these types of agreements do happen between people, and they're presumptively valid unless they're preventing someone from disclosing illegal things to the government. That's when they would be, unenforceable or some other awful thing that could be there. But you can actually sell your silence on a non-legal issue to someone if they're willing to pay you. It's cool. Contract law is neat. So anyway, Mr. Cohen subsequently prepared a draft non-disclosure agreement and presented it to Miss Clifford and her attorney, the, quote, hush agreement. Miss Clifford at the time was represented by counsel in California, whose office is located in Beverly Hills, California, within the county of Los Angeles. Not sure why they don't list her attorney's names there. The attorney's names are later in the document, so we'll talk to them. The parties named in the hush agreement were Miss Clifford, Mr. Trump, and Essential Consultants, LLC. As noted above, Essential Consultants, LLC, henceforth known as EC, was formed on October 17th, 2016, just weeks before the 2016 presidential election. On information and belief, EC was created by Mr. Cohen with Mr. Trump's knowledge for one purpose: to hide the true source of funds to be used to pay Miss Clifford, thus further insulating Mr. Trump from later discovery and scrutiny. By design of Mr. Cohen, the hush agreement used aliases to refer to Miss Clifford and Mr. Trump. Specifically, Miss Clifford was referred to by the alias Peggy Peterson, or PP. Mr. Trump, on the other hand, was referred to by the alias David Dennison, or DD. Attached hereto as Exhibit 1 is a true and correct copy of the hush agreement titled Confidential Settlement Agreement and Mutual Release, Assignment of Copyright and Non-Disparagement, SIC Agreement, because they misspelled disparagement. Good job, Michael Cohen. Being a high-paid attorney, has no time for spelling. Exhibit 1 is incorporated herein by this reference and made part of this complaint as if fully set forth herein. Attached hereto as Exhibit 2 is a true and correct copy of the draft side letter agreement, which was Exhibit A to the hush agreement. Exhibit 2 is incorporated herein by this reference and made part of this complaint as if fully set forth herein, and we will go through those documents too. Importantly, the hush agreement imposed various conditions and obligations not only on Miss Clifford but also on Mr. Trump. The agreement also required the signature of all parties to the agreement, including that of Mr. Trump. Moreover, as is customary, it was widely understood at all times that unless all the parties signed the documents as required, the hush agreement, together with all of its terms and conditions, was null and void. On or about October 28, 2016, only days before the election, two of the parties signed the hush agreement, Miss Clifford and Mr. Cohen, on behalf of EC. Mr. Trump, however, did not sign the agreement, thus rendering it legally null and void and of no consequence. Or is it? Dun, dun, dun. Sorry to be dramatic. We'll get there. That's an interesting question in this case, actually. So we'll talk about that when we get to the agreement. But keep that in mind. On information and belief, despite having detailed knowledge of the hush agreement and its terms, including the proposed payment of money to Miss Clifford and the routing of those monies through EC, Mr. Trump purposely did not sign the agreement so he could later, if need be, publicly disavow any knowledge of the hush agreement and Miss Clifford. Despite Mr. Trump's failure to sign the hush agreement, Mr. Cohen proceeded to cause $130,000 to be wired to the trust account of Miss Clifford's attorney. He did so even though there was no legal agreement and thus no written non-disclosure agreement whereby Miss Clifford was restricted from disclosing the truth about Mr. Trump. Did he? Did he? That's not something lawyers tend to do, but, maybe wiring $130,000 to someone when you don't have an agreement is a weird practice for lawyers. So I am a little skeptical of this claim, but we will keep going. On or about, let's see. Mr. Trump was elected president of the United States on November 8th, 2016. In January 2018, certain details of the draft hush agreement emerged in the news media. Now, how would that happen? How would they emerge in the news media? This right away is a problem for all of this because, it sure looks like Miss Daniels or her attorney violated the non-disclosure agreement by leaking it to the media. But I don't know. Let's see. So, emerged in the news media, including among other things, the existence of the draft agreement, the parties to the draft agreement, and the $130,000 payment provided for under the draft agreement. So it kind of looks like the whole draft agreement was provided. Just saying. Also in January 2018, and concerned the truth would be disclosed, Mr. Cohen, through intimidation and coercive tactics, forced Miss Clifford into signing a false statement wherein she stated that reports of her relationship with Mr. Trump were false. What's interesting is that they don't allege at all what the coercive tactics and intimidation he used were. Did he call and say, "We have a non-disclosure agreement, you better not say anything, it looks like you violated it and we will come after you"? That's not intimidation and coercion. That's just a legal reality of you breaching a non-disclosure agreement. So I really wish they would have fleshed out what specific intimidation and coercive tactics Mr. Cohen is alleged to have used. Because if they're illegal things, we want to stop that. But if they're legal things like asserting your right not to have a mutually agreed to contract broken, then, that's not really punishable. On or about February 13th, 2018, Mr. Cohen issued a public statement regarding Miss Clifford, the existence of the hush agreement, and details concerning the hush agreement. He did so without any consent by Miss Clifford, thus evidencing Mr. Cohen's apparent position, at least in that context, that no binding agreement was in place. Let me preview this for you. I haven't seen, and I'm going to read through it with you guys, so if you catch this later, let me know in the comments if I don't catch it, but I have not seen anything that binds Trump or Cohen or anyone other than Miss Clifford from disclosing any of this. I don't see anything in that agreement where their disclosure of it somehow voids the agreement. I actually see some specific language to the contrary. So that's a little interesting. But remember that, and we'll touch on it. And if you guys find that provision in the contract and I don't, please let me know in the comments. Among other things, Mr. Cohen stated, in a private transaction in 2016, I used my own personal funds to facilitate a payment of $130,000 to Miss Stephanie Clifford. Neither the Trump Organization nor the Trump campaign was a party to the transaction with Miss Clifford, and neither reimbursed me for the payment, either directly or indirectly. Mr. Cohen concluded his statement with lawyer speak. says the lawyer who drafted this, to the judge who's also a lawyer. Just because something isn't true doesn't mean that it can't cause you harm or damage. That is a true statement. That's not lawyer speak. That's reality. If someone is lying about you, it can certainly cause you harm and damage. I will always protect Mr. Trump. Emphasis added. Why? Why add emphasis to an obvious statement? He is his personal attorney. It is literally his job to protect him. That's the purpose of an attorney. Guys, if you hire me, I will always protect you. This is just how attorneys work. And it's weird that they're emphasizing this because a judge knows this. It's almost like this document is made for public consumption, but I'm not, that might be a bit presumptuous. Importantly, at no time did Mr. Cohen claim Miss Clifford did not have an intimate relationship with Mr. Trump. No, he didn't claim that. It's not really necessary. Never mind. Indeed, were he to make such a statement, it would be patently false. Okay. Because the agreement was never formed and or is null and void, no contractual obligations were imposed on any of the parties to the agreement, including any obligations to keep information confidential. Moreover, to the extent any such obligations did exist, they were breached and or excused by Mr. Cohen in his public statements to the media. I find that hard to believe. So just a brief pause, guys. What they're asking for in this lawsuit is merely a statement from the court, a ruling as a matter of law that whatever agreement might have existed no longer does or never existed in the first place. That's what they're asking for. They're not asking for anything other than this doesn't exist and I can talk to whoever I want. That's what they're trying to do. Interestingly, they don't just talk to whoever they want, because if they truly believe that no agreement existed, maybe they would do that. They would make the statements first and then later, face the potential court fallout, which would still force Trump to defend it. So I don't know, I don't know why, if they believe that there is no agreement, that they're not just going through with it, but that's okay. To be clear, the attempts to intimidate Miss Clifford into silence and, quote, shut her up, I don't know who they're quoting there, in order to, quote, protect Mr. Trump, continue unabated. Presumably, they're trying to impute shut her up to Michael Cohen. I'm not sure. He's not quoted as saying that anywhere else. For example, only days ago, on or about February 27th, 2018, Mr. Trump's attorney, Mr. Cohen, surreptitiously initiated a bogus arbitration proceeding against Miss Clifford in Los Angeles. That's because I believe this non-disclosure agreement has a mandatory arbitration clause in it. And by I believe, I mean it does. Remarkably, he did so without even providing Miss Clifford with notice of the proceeding in basic due process. Maybe. We have no idea if he did that or not. Maybe he provided it to the other attorneys. Not sure. Put simply, considerable steps have been taken by Mr. Cohen in the last week to silence Miss Clifford through the use of an improper and procedurally defective arbitration proceeding hidden from public view. Sidebar, that Miss Clifford agreed to in a negotiated non-disclosure agreement that we will be reading ahead. And guys, I'm adding commentary that seems to support Trump's side of this, mainly because some of these statements are overtly problematic in the scope of the agreements. Not because I have any vested interest in Trump being right or wrong in this. This is all theater to me, and I don't care who wins. It doesn't matter. Trump loses on this issue immediately with the fact that this video even exists, because this video indicates that the public now knows all of these details, and whether or not they even are true against him, they will be given to him. That's just how public life works. Okay. The extent of Mr. Trump's involvement in these efforts is presently unknown, but it strains credibility to conclude that Mr. Cohen is acting on his own accord without the express approval and knowledge of his client, Mr. Trump. Except that I believe they said that Mr. Cohen signed on behalf of EC, not on behalf of Mr. Trump. And it is okay for lawyers to represent multiple clients. So who knows? Indeed, Rule 1.4 of the New York Rules of Professional Conduct governing attorneys has required Mr. Cohen at all times to promptly communicate all material information relating to the matter to Mr. Trump, including but not limited to any decision or circumstance with respect to which Mr. Trump's informed consent was required, and material developments in the matter, including settlement or plea offers. Now, this all presumes and requires the presumption that Trump is the one bringing the claim and not Michael Cohen and not EC. If Trump might not need to be, his informed consent might not be required, and the material developments, including settlement or plea offers, may not involve him at all, especially if he didn't give the money to Michael Cohen, and Cohen did it, on his own. That Trump might not need to be notified. So this isn't necessarily a rule violation, but it looks like one. It does look like a rule violation in regards to this, if Trump is not being informed and if it's necessary. But these rules are a little slippery, because lawyers wrote them to police themselves. Remember that. Lawyers wrote professional rules to police themselves. So the moment you think you have a lawyer pinned down on an ethics violation, watch out. They're slimy and wiggly. Moreover, the same rule required Mr. Cohen at all times to reasonably consult with Mr. Trump about the means by which his objectives are to be accomplished and to keep Mr. Trump reasonably informed about the status of the matter. Accordingly, unless Mr. Cohen flagrantly violated his ethical obligations and the most basic rules governing his license to practice law, which is highly unlikely, there can be no doubt that Mr. Trump at all times has been fully aware of the negotiations with Ms. Clifford, the existence and terms of the hush agreement, the payment of the $130,000, the use of EC as a conduit, and recent attempts to intimidate and silence Ms. Clifford by way of the bogus arbitration proceedings. There can be some doubt. Let's be clear. There can be some doubt because this is all operating under the assumption that Trump is the necessary party to the contract, which isn't 100%, it's not 100%. It may be true, but it's not 100% true. Or not 100% required to be true. Because there was never a valid agreement and thus no agreement to arbitrate, any subsequent order obtained by Mr. Cohen or Mr. Trump in arbitration is of no consequence or effect. It might be, though. So the first cause of action. So that was the facts section. And now these are the cause of action are legal claims and the basis for them. First cause of action is declaratory relief against all defendants. Plaintiff restates and realleges each and every allegation in paragraphs 1 through 33 above as if fully set forth herein. This action concerns the legal significance, if any, of the documents attached hereto as Exhibit 1, entitled Confidential Settlement Agreement and Mutual Release, Assignment of Copyright and Non-Disparagement Agreement, and Exhibit 2, entitled Side Letter Agreement. California Code of Civil Procedure, Section 1060, authorizes declaratory relief for any person who desires a declaration of rights or duties with respect to one another. In cases of actual controversy relating to the legal rights and duties of the respective parties, such a person may seek a judicial declaration of his or her rights and duties relative to an instrument or contract or alleged contract, including a determination of any question of construction or validity arising under the instrument or contract or alleged contract. This includes determination whether a contract was ever formed. So they're asking the court to determine if this non-disclosure agreement is valid or if it even existed in the first place. An actual controversy exists between plaintiff and defendants as to their rights and duties to each other. Accordingly, a declaration is necessary and proper at this time. Specifically, plaintiff seeks an order of this court declaring that the agreements in the form set out in Exhibits 1 and 2 between plaintiff and defendants were never formed and therefore do not exist because, among other things, Mr. Trump never signed the agreements. Did he not sign them? That'll be the question, and that'll be part of the question. We'll get there. There's just an interesting block of language that kind of speaks directly to this. Nor did Mr. Trump provide any other valid consideration. Okay, but you're alleging that he facilitated a $130,000 transfer through a shell corporation, and that is the consideration. So either he did that or he didn't do that. That's weird. He thus never assented to the duties, obligations, and conditions the agreements purportedly imposed upon him. Plaintiff contends that, as a result, she is not bound by any of the duties, obligations, or conditions set forth in Exhibits 1 and 2. Moreover, as a further result, there is no agreement to arbitrate between the parties. In the alternative, plaintiff seeks an order of this court declaring that the agreements in the form set out in Exhibits 1 and 2 are invalid, unenforceable, and or void under the doctrine of unconscionability. Plaintiffs contend that as a result, she is not bound by any of the duties, obligations, or conditions set forth in Exhibits 1 and 2. Moreover, as a further result, there is no agreement to arbitrate between the parties. Let me take a brief pause here. Unconscionability is a tough standard in a private contract where both parties are represented and presumably negotiate the terms of the agreement. And when both parties are represented and sign the document, then both parties are presumed to have negotiated the terms of the agreement, because if you didn't agree, you just wouldn't sign the document. You wouldn't accept a $130,000 wire transfer, and therefore you wouldn't have an agreement. But let's assume that they did accept it, and now she's saying that it is unconscionable. Well, unconscionability is tough because it means that it has to be against the conscience of the court to enforce the agreement. And if the agreement is merely, I won't speak to anyone about my relationship with another person, and I'm going to accept 6 figures of money to not talk to other people, that's not unconscionable. That's not unconscionable at all, unless it's hush money to cover up a criminal act. A criminal act would be hush money. So if, say, Miss Daniels, Miss Clifford, was witness to Mr. Trump murdering someone, and then he paid her money to keep her quiet, that's unconscionable. Enforcing that would be unconscionable. But merely promising not to talk, non-disclosure agreements happen pretty much all the time, especially in contemplation of litigation, as seems to be the case with this one, where they're saying, look, we don't want to sue you for defamation, because that's the implied problem here, as we'll see in the document. We don't want to sue you for defamation. It's expensive. It's pointless. Why don't instead we just pay you now and you not say whatever you're planning on saying? That's a legal agreement. It's not unconscionable. So this is a problematic claim. Let's see. In further alternative, plaintiff seeks an order for this court declaring that the agreements in the form set out in Exhibits 1 and 2 are invalid, unenforceable, and or void because they are illegal and or violate public policy. They haven't laid out anything that makes them illegal or violating public policy. This is a Hail Mary pass, asking the judge to please find something that makes it illegal. But nothing in their facts section, nothing in this cause of action alleges specifically the illegality or the statute that they'd be violating or the case law that they'd be breaking. And that is a poorly drafted complaint. Like I said, it looks like kind of a Hail Mary there. Moreover, as further result, there's no agreement to arbitrate the dispute between the parties. Defendants dispute these contentions. Well, I'm sure they do. But you can't determine the defendants dispute things until the defendants actually answer and do dispute them. So that's a little weird. Accordingly, Ms. Clifford desires a judicial determination of her rights and duties with respect to the alleged agreements in the form set out in Exhibits 1 and 2. Prayer for relief. Wherefore, plaintiff prays for judgment against defendants and each of them, declaring that no agreement was formed between the parties, or in the alternative, to the extent an agreement was formed, it is void, invalid, or otherwise unenforceable. It's interesting that in their cause of action, they didn't allege that the agreement was void due to it being breached by Mr. Cohen's disclosure, because that was something they stated in the facts section, and why it's not in the causes of action here is baffling. Like that, I don't think it's a good claim based on the language of the document, and maybe they don't either, but they did bring it up in the facts section. They should have put it down here. I mean, it's a better claim than this last one, in my opinion. On the first cause of action, for a judgment declaring that no agreement was formed between the parties, or in the alternative, to the extent an agreement was formed, it is void, invalid, or otherwise unenforceable, for costs of the suit, and for such other and further relief as the court may deem just and proper. So that's signed by Michael J. Avenatti, attorney for the plaintiff. So here is Exhibit 1. Now, guys, this is a contract, and it is a little lengthy, and it is a little thick. I'm going to read through it as fast as I can on the dense boilerplate topics, and I will then try and talk about any important or salient points that come out of it. So stick with me. This can be a little dry. The settlement agreement and mutual release hereinafter this agreement is made and deemed effective as of the 20th day of October 2016 by and between EC LLC and or David Dennison on the one part and Peggy Peterson PP on the other part. EC LLC, DD, and PP are pseudonyms whose true identity will be acknowledged in a side letter agreement attached hereto as Exhibit A. This agreement is entered into with reference to the facts and circumstances contained in the following recitals. So immediately we have an issue for Mrs. Clifford. Now, one, none of them are named here. Miss Clifford is named in the side letter. The other names are redacted in the side letter, so I'm not entirely sure. But this is between EC and or David Dennison and or. So if David Dennison is Trump, EC can act as one of the parties to this, which immediately satisfies that consideration part, considering that EC apparently wired the money to Peggy Peterson. This agreement, so EC, LLC, DD, and PP are pseudonyms whose true identity will be acknowledged in a side letter agreement attached hereto as Exhibit A. This agreement is entered into with reference to the facts and circumstances contained in the following recitals. So recitals. Prior to entering into this agreement, PP came into possession of certain, quote, confidential information pertaining to DD, as more fully defined below, only some of which is in tangible form, which includes but is not limited to information, certain still images and or text messages which were authored by or relate to DD, collectively the property, each as more fully defined below, but which all are included and attached hereto as Exhibit 1 to the side letter agreement. PP claims that she has been damaged by DD's alleged actions against her, including but not limited to tort claims proximately causing injury to her person and other related claims. DD denies all such claims. Hereinafter, PP claims. DD claims that he has been damaged by PP's alleged actions against him, including but not limited to the alleged threatened selling, transferring, licensing, publicly disseminating, and or exploiting the images and or property and or the other confidential information relating to DD, all without the knowledge, consent, or authorization of DD. PP denies all such claims. Hereinafter, DD claims. So this alone probably satisfies consideration for both parties, in that each party has something that the other person doesn't want them to talk about. They are damaged. PP is damaged. DD is damaged. You know, I'm not sure what alleged actions, tort claims proximately causing injury to her person and other related claims. I'm not sure if that means that he physically attacked or assaulted or injured her. And that's kind of that's an interesting sort of, point, but the tort could be economic damages. Who knows? The PP claims and the DD claims are hereinafter collectively referred to as the released claims. DD desires to acquire and PP desires to sell, transfer, and turn over to DD any and all tangible copies of the property and any and all physical and intellectual property rights in and to all of the property. As a condition of DD releasing any claims against PP related to this matter, PP agrees to sell and transfer to DD all of each of her rights in such property. PP agrees to deliver each and every existing copy of all tangible property to DD and permanently delete any electronic copies that cannot be transferred, and agrees that she shall not possess nor directly nor indirectly disclose, convey, transfer, or assign property or any confidential information to any third party as more fully provided herein. So she's going to give all of the pictures and texts and documents to DD and then delete any copies that she would hold. It is the intention of the parties that confidential information as defined herein shall remain confidential as expressly provided herein below. Parties expressly acknowledge, agree, and understand that the confidentiality provisions herein and the representations and warranties made by PP herein and the execution of by her of the assignment and transfer of copyright are the essence of this settlement agreement and are material inducement to DD's entry into this agreement, absent which DD would not enter into this agreement. DD expects and requires that PP never communicate with him or his family for any reason whatsoever. The parties wish to avoid the time, expense, and inconvenience of potential litigation to resolve any and all disputes and potential legal claims which exist or may exist between them as of the date of this agreement, including but not limited to PP claims and or the DD claims. The parties agree that the claims released include but are not limited to DD's claims against PP as relates to PP having allowed, whether intentionally, unintentionally, or negligently, anyone else other than those listed in Section 4.2 here and below to become aware of the existence of and content of the property, to have gained possession of the property, and to PP's having allegedly engaged in efforts to disclose, disseminate, and or commercially exploit the images and or property and or confidential information, and any harm suffered by DD therefrom. The parties agree that the claims released include but are not limited to PP's claims against DD, as relates to DD having allowed, whether intentionally, or unintentionally, or negligently, anyone else to have interfered with PP's right to privacy or any other right that PP may possess. That's a lot. That's a lot of boring. But it basically says that they both have interests in resolving this outside of the courts. These recitals are essential, integral, and material terms of this agreement, and this agreement shall be construed with respect thereto. The parties entered into this agreement in consideration of the promises, covenants, and conditions set forth herein, and for good and valuable consideration, the receipt of which is hereby acknowledged. It is an essential element of this settlement agreement that the parties shall never directly or indirectly communicate with each other or attempt to contact their respective families. This matter, the existence of this settlement agreement and its terms are strictly confidential. Now, therefore, the parties adopt the foregoing recitals as a statement of their intent and in consideration of the promises and covenants contained herein, and further agree as follows. Settlement terms. EC LLC shall pay to PP $130,000 US as follows. $130,000 shall be wired to PP's attorney-client trust account on or before 1600 hours PST on 10/27/16. Here's the wiring instructions. They really should have redacted the account number, but they didn't, so who knows. Keith M. Davidson, Esquire, who was the attorney for Ms. Clifford, shall receive the gross settlement amount in trust. No portion of the gross settlement amount shall be dispersed by attorney for PP unless and until PP executes all required settlement documents. Undertakings and obligations by PP. PP will do each of the following by 11/01/16. PP shall execute this agreement and return a signed copy to DD. PP shall transfer and or assign any and all rights in and to the property to DD as set forth herein below, and execute an assignment and transfer of copyright in the form attached hereto, and return a signed copy of the same to DD's counsel. So they're going to turn over the stuff, the rights to all the stuff as well. PP shall deliver to DD every existing copy of all tangible property. PP shall completely divest herself of any and all artistic media, impressions, paintings, video, images, still images, email messages, text messages, Instagram message, Facebook posting, or any other type of creation by DD. PP shall transfer all physical ownership and intellectual property rights to DD. PP shall deliver to DD any and all non-privileged correspondence concerning or relating to DD between PP and any third party. So anything other than to her attorney, basically, she'll have to turn over. Any communications about him, that's part of the agreement. PP shall not at any time from the date of this agreement forward directly or indirectly disclose or disseminate any of the property or any confidential information, including confirmation of the fact that it exists or ever existed, and or confirming any rumors as to any such existence to any third party as more fully provided herein. PP shall provide to DD, to the extent not already done so and set forth in paragraph 4.2 herein below, summary details disclosing to whom PP or anyone else on PP's behalf disclosed, displayed to, disseminated, transferred to, provided a copy to, and or distributed, sold, licensed, or otherwise sought to have commercially exploit the images and or property and or confidential information. So they're asking for anyone they may have given any of these things to so they can go buy them off. That's the whole point of that page, or that part. PP shall provide to DD's counsel the names and contact information of each and any persons or entities who PP has provided to or would otherwise have obtained possession of the original and or copies of any of the images and or any property, if any, to whom PP has scanned the images and or any property at any time, and 3, to whom PP has, or may potentially have possession of a copy of the images and or any property at any time, including but not limited to the present time, and specifically with detail to which the reference categories, i.e. possession, shown, past, present, etc. Any name corresponds, the name so relates. So again, asking for information about who might have any of this stuff. PP shall provide to DD's counsel copies of any agreements and or other documentation in PP's possession, custody, and control, if any, regarding E and or F above, that evidences who may have been provided a copy of any of the property. So if she sold any of this stuff to a news outlet, then there would be some sort of contract, and that contract should be disclosed. Transfer of property rights to DD. I am not going to read this section. You're welcome. This is, again, the transfer of intellectual property rights in anything that they might have. It's really, I mean, you guys can read it if you want, but it's giving all of the intellectual property or intangible rights to DD. So if she were to acquire a copy and attempt to reproduce it, she would not have the right to do so, and would therefore potentially be, some sort of copyright claim. Whew, that's a long section. So for greater certainty, the foregoing assignment shall be acceptable or applicable worldwide. So this does not just cover United States or the state of California. This would be anywhere on earth. He has the rights to any of this property that would be in her possession. Notwithstanding the foregoing paragraph 3.2, and without in any way limiting or diminishing from the full transfer and assignment of rights therein without reservation, the parties understand the purpose of the transfer of rights is to provide DD the fullest possible ability and remedies to prevent and protect against any publication and or dissemination of the property. Right. Delivery of the property to DD. Oh, man. Concurrently upon execution of this agreement, PP, as applicable, shall deliver to DD by delivery of his counsel herein. So she's going to deliver it to Cohen. All of the property which is embodied in tangible form, all originals and duplicates, whether documents, canvases, paper, art, digital copies, letters, prints, electronic data, films, tapes, CD-ROMs, DVD-ROMs, images, recording tapes, photographs, negatives, originals, duplicates, contact sheets, audio recordings, images, recordings, magnetic data, computerized data, digital recordings, or other recorded medium on any other format of embodying information or data. Without limiting the generality of the foregoing, such tangible property shall include all documents as defined by California Evidence Code Section 250, which contain any of the property. Wow. There's a lot more of this, but basically, again, any type of medium, it covers all of it. If you have it on 8-track, you got to give it up. All of it. All of it is covered. They're trying to be as thorough as possible. The property delivered under this paragraph shall become Exhibit 1 to the side letter agreement. For avoidance of any doubt, PP nor her attorney are entitled to retain... For the avoidance of any doubt, PP nor her attorney are entitled to retain possession of said property after execution of this agreement. The retention of said property by PP is a material breach of this agreement. This agreement is conditioned on PP's compliance with each and every term of the settlement agreement, including paragraph 3.3, and the personal verification by DD or his attorney of the images and that the images are comprised of and captures the content previously represented to his counsel to exist and be captured therein, i.e. text messages between PP and DD, all of which terms are essential and material. So all of this is critical to the agreement. They have to deliver everything. Otherwise, there is no agreement. Confidentiality and representations and warranties. So here we go. Definition of confidential information. Confidential information means and includes each and all the following. All intangible information pertaining to DD and or his family, including but not limited to his children or any alleged children of his alleged sexual partners, alleged sexual actions or alleged sexual conduct or related matter, and or friends learned, obtained, or acquired by PP, including without limitation information contained in letters, emails, text messages, agreements, documents, audio or image recordings, electronic data, and photographs. So this is any intangible information related to DD or anybody he knows or has been with or is a friend of or is a business associate with, whoever. All intangible information pertaining to the existence and content of the property. So this would be like any documents stored on a computer that talk about the property, any emails in which lists of the property might be kept or anything like that, or it might be described to someone. That is also intangible information that is confidential and can no longer be disclosed. All intangible private information, i.e. information not generally available and to and or known by the general public relating and or pertaining to DD, including without limitation DD's business information, familial information, any of his alleged sexual partners, alleged sexual actions or alleged sexual conduct, related matters, or paternity information, legal matters, contractual information, personal information, private social life, lifestyle, private conduct. All information / items in 4.1 A, B, and C are sometimes collectively referred to as intangible confidential information. And then all tangible materials of any kind containing information pertaining to DD, learned, obtained, participated, or acquired by PP, including without limitation letters, agreements, documents, audio or images, recordings, electronic data and photographs, canvas art, paper art, or art in any other form or on any media. The images and photos and all information items in 4.1D are collectively referred to as the property and or the tangible confidential information. So PP's representations and warranties regarding prior disclosures of tangible confidential information. PP represents and warrants that prior to the entry of this agreement, PP has directly or indirectly disclosed any tangible and or intangible confidential information, i.e. any of the property, to any third party, including without limitation disclosure or indirect disclosure of the content of such confidential information in tangible form, other than the following persons or entities to whom PP has made such prior disclosures. Herein, PP disclosed individual entities. Mike Moshe, Angel Ryan, Gina Rodriguez, and Keith Munyon. I don't know who any of those people are. Doesn't matter. She told those 4 people about these things. PP shall not be responsible for any subsequent public disclosure of any of the confidential information attributable directly to each of them and or not disclosed here and above as previously disclosed. PP disclosed individuals, entities, and any such disclosure shall be deemed a breach of this agreement by PP. Whoa. Okay. So PP shall not be responsible for any subsequent public disclosure of any of the confidential information attributable directly to each of the 4 people listed above, and or not disclosed above as previously disclosed. Not disclosed here and above as a previously disclosed PP disclosed individual entity. So anyone other than these 4 that she has already communicated to Cohen and or Trump knows this information is a previously disclosed PP disclosed individual entity. And any such disclosure shall be deemed, so disclosure other than the stuff mentioned just before. This is a really confusing paragraph. Sorry that lawyers are like this. Shall be deemed a breach of this agreement by PP. For greater clarity, PP must not induce, promote, or actively inspire anyone to disclose confidential information. So she can't say, hey, I signed a non-disclosure agreement. You guys need to talk about it. Representations and warranties and agreements by DD. So here's that whole, he didn't provide any consideration. Well, here's his consideration pretty specifically, other than the $130,000. The following agreements, warranties, and representations are made by DD as material inducements to PP to enter into this agreement, and each party acknowledges that he is executing this agreement in reliance thereon. So again, PP is agreeing that this is sufficient consideration. So DD warrants and represents that, as relates to or in connection with any of PP's attempts to sell, exploit, and or disseminate the property prior to the date of this agreement, DD and his counsel will refrain from pursuing any civil action against PP and or, absent a direct inquiry from law enforcement, from disclosing PP's name to the authorities. Notwithstanding the foregoing, if DD is informed that or if it is believed that either of PP has possession, custody, and or control of any of the property after the date of this agreement, and or transferred any copies to any third party, and or it is believed that any of PP, whether directly or indirectly, intends to the release, use, display, dissemination, disclosure, or exploitation, whether actual, threatened, or rumored, of any for the property, then DD and his counsel shall be entitled to, at DD's sole discretion, 1, contact the respective member of PP, including with legal demands and related statements of liability and legal action, and or advance a civil action against the respective member of PP, and or disclose any of PP's name to the authorities. That's a really clunky statement, and I think it's because this non-disclosure agreement is probably written typically between organizations and not individuals. If I had to guess, that's the template that Cohen was using here is a form non-disclosure agreement that would be between or maybe customized, probably customized, but a basic form that is followed for business dealings of Trump. Representation, warranties, and agreements by PP. The following agreements, warranties, and representations were made by PP as material inducements to DD to enter this agreement, without which DD would not enter this agreement, and without which DD would not agree to pay any monies whatsoever hereunder. And with the express acknowledgement that DD is executing this agreement in reliance on the agreements, warranties, and representations herein, which are at the essence of this agreement, including the following. PP agrees and warrants and represents that PP will permanently cease and desist from any efforts and or attempting to and or engaging in and or arranging the use, license, distribution, dissemination, or sale of any of the confidential information and or property, including any tangible and or intangible confidential information created or related to DD. PP agrees and warrants and represents that PP will permanently cease and desist from any posting or dissemination or display of the confidential information, tangible and or intangible confidential information created by or relating to DD and or property, including the images, including but not limited to any form media outlet, on any blog or posting board on the internet or otherwise. PP agrees and warrants and represents that PP will permanently cease and desist from using or disseminating or disclosing any information to any third persons, including but not limited to any media outlet or any blog, posting board, or the internet or otherwise, about any details as to the contents of the confidential information, tangible or intangible confidential information created by or relating to DD and or property, including any text messages, and or as to any other personal details of or about or pertaining to DD and or his family and or friends and or social interactions. Holy cats, this is thick. PP agrees and warrants and represents they will permanently cease and desist from... Guys, this is the same stuff over and over in more clarity. PP promises not to give any information about DD to anyone. There. I summed all of that up. And says that has not assigned nor transferred, either in whole or in part, any rights in or to the images and or property or to any other person or entity other than to DD pursuant to this agreement. Okay, so then here's agreement by PP not to disclose or use confidential information. This is the same thing. Okay. I wasn't going to read this because it's really long, but this is an important paragraph in regards to the claims. Remember, I told you to watch for this. So here we go. Agreement by PP not to disclose, use confidential information. Agreement by PP. Tangible and or intangible confidential information created by or relating to DD as further material inducements for DD to enter into this agreement. PP agrees, represents, and warrants that she shall not directly or indirectly, verbally or otherwise, publish, disseminate, disclose, post, or cause to be published, disseminated, disclosed, or posted, herein disclose, any confidential information and or tangible and or intangible confidential information created by or relating to DD to any person, group, firm, or entity whatsoever, including but not limited to family members, friends, associates, journalists, media organizations, newspapers, magazines, publications, television or radio stations, publishers, databases, blogs, websites, posting boards, and any other enterprise involved in the print, wire, and electronic media, including individuals working directly or indirectly for or on behalf of any of the said persons or entities, third parties, and or third party. In no event shall PP be relieved of such parties' confidentiality obligations herein by virtue of any breach or alleged breach of this agreement. So, even if Cohen is alleged to have breached this agreement, PP is not relieved of such parties' confidentiality obligation of the confidentiality obligation. In no event shall any dispute in connection with this agreement relieve PP of her confidentiality obligations arising pursuant to this agreement, and any disclosure of confidential information and or tangible or intangible confidential information created by relating to DD in connection with any such proceeding or dispute shall constitute a breach of this agreement. Oh, cats, excuse me. Woo! PP shall use their best efforts to prevent the unauthorized disclosure of confidential information in connection with any such proceeding or dispute. So, now, you cannot, if there's a breach, you can't hold them to the agreement. If there's a breach, there's a breach. But if there's an alleged breach, you can't decide that you can then go ahead and breach this. You have to find a ruling of the breach. You have to, yeah. So, and that's what they're trying to do here. And that's probably why they haven't just released the information, is because they think that this actually might be binding. But, and I think it might be too. So, any direct or indirect disclosure of confidential information or tangible and or intangible confidential information creating by or relating to DD to any third party by PP or any of her representatives, heirs, agents, children, family members, relatives, blah, 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 everybody on earth after the date of this agreement shall be deemed a disclosure by PP in breach of the terms of this agreement, entitling the non-breaching party to all rights and remedies set forth herein. PP separately and further warrants and represents that prior to entering into this agreement, she's not given this to anybody else. Okay. Agreement by PP not to disparage DD. PP hereby irrevocably agrees and covenants that she shall not directly or indirectly publicly disparage DD, nor write, publish, cause to be published, or authorize, consult about, or with, or otherwise be involved with, in the writing, publication, broadcast, transmission, or dissemination of any book, memoir, letter, story, photograph, film, script, images, interview, article, essays, biography, diary, journal, documentary, or other written, oral, digital, or visual account or description or depiction of any kind whatsoever, whether fictionalized or not, about DD or his family, whether truthful, laudatory, defamatory, disparaging, deprecating, or neutral. PP further warrants and represents that PP has not or will not enter into any written or oral agreement with any third party purportedly requiring or obligating PP to do so. For greater clarity, for is misspelled. Good job. PP will never discuss with anyone the contents of this settlement agreement, nor will she voluntarily confirm the existence of this settlement agreement. There you go. Disclosure of confidential information is prohibited. Again, this is the same. It's how lawyers do things as they write it over and over. If you note, PP on all these pages is initialed, presumably by Stormy Daniels, Miss Clifford. EC is initialed here over DD. And remember that EC is the LLC that can act and or in the place of DD. So along with or in substitution for. Disclosures permitted by PP. Notwithstanding the foregoing, believe it or not, they apparently haven't prevented her from speaking entirely about everything. Notwithstanding the foregoing, PP shall only be permitted to disclose confidential information to another person or entity only if compelled to do so by valid legal process, including without limitation a subpoena, duces tecum, or similar legal compulsion, provided that PP shall not make any such disclosures unless PP has first provided DD with such notice, with notice of such order or legal process not less than 10 days in advance of the required date of disclosure pursuant to the written notice provisions set forth here and below, providing DD with an opportunity to intervene and with full and complete cooperation should she choose to oppose such disclosure. Okay, so yeah, if she's subpoenaed, she's supposed to tell Trump or whoever, and then they will have an opportunity to step in and write a motion as to why that stuff cannot be disclosed. Great. Remedies. DD's remedies for breach of contract. Each breach or threatened breach, including without limitation by breach of any representation or warranty, by failing to deliver to DD all tangible property as required by the disclosure or threatened disclosure of any confidential information to any third party by PP herein protected communication, or otherwise shall render PP liable to DD for any and all damages and injuries incurred as a result thereof, including but not limited to the following, all of which rights and remedies shall be cumulative. A disgorgement of money. So I'm going to start summarizing, guys. This gets really long and it's really thick and it's boring. Disgorgement of money. So any money that Miss Clifford were to obtain from the disclosure of the information goes to Trump. Liquidated damages means, basically any damage that would be caused to Trump would be really hard to determine. So they're agreeing that there would be a specific amount. So here we go. So therefore, in addition to the disgorgement of the full amount of all monies or other consideration pursuant to paragraph 5.12, in the event an arbitrator determines there has been a breach of the LD breach terms of this agreement by PP individually or the PP group, PP shall also be obligated to pay and agree to pay to DD the sum of $1 million as a reasonable and fair amount of liquidated damages to compensate DD for any loss or damage resulting from each breach. It is being understood that the liquidated damage calculation is on a per item basis. Alternatively, at DD's sole discretion, DD may seek to recover actual damage approximately caused by each such breach according to the proof. Any other breaches not a LD breach terms. Any other breaches not a LD breach terms shall be subject to a claim for actual damages according to proof. Furthermore, any monies held in trust by PP's attorney shall be frozen and shall not be dispersed until the arbitrator finally resolves such allegation of breach. Injunctive relief, stop them from releasing the information. Dispute resolution. So this is the arbitration clause. I'm not going to read all of it because it's really boring. But it basically says that if there's a dispute about this agreement between these two parties, they have to go to either arbitration before JAMS and dispute, which is JAMS, pursuant to JAMS comprehensive arbitration rules, or the Action Dispute Resolution Services, ADRS, pursuant to their rules, including interim measures. And then DD has the choice of forum, which in JAMS would be either California, Nevada, or Arizona, and DD would be, it says, whichever the claimant elects upon filing an arbitration. So whichever forum is allowed, in ADRS, presumably they can choose. The arbitrator shall be decided on by both parties. So both parties have to agree on the arbitrator, or if both parties cannot agree on an arbitrator, then one will be picked according to the rules of whichever arbitration service. And both of these are large arbitration services. They're not like special Trump-only shops. You know, you may know someone who has been through a JAMS arbitration. Anyway, these are these are bigger companies. So it's not like a privately owned, scary, secret police type thing. So the arbitrator can impose all legal and equitable remedies. So then here's in bold. Each of the parties understands, acknowledges, and agrees that by agreeing to arbitration as provided herein, each of the parties is giving up any right that he, she, it might have to a trial by judge or jury with regard to the matters which are required to be submitted to mandatory and binding arbitration pursuant to the terms thereof. Each of the parties further understands, acknowledges, and agrees that there is no right to an appeal or a review of an arbitrator's award, as there would be a right to appeal or review of a judge or jury's decision. So this is this is a very clear and obvious arbitration decision. If the court finds that a valid agreement exists at all, then this needs to go to an arbitrator, period. They agreed to it. The arbitration isn't unconscionable. It says the cost shall be split equally amongst the parties. I believe Miss Daniels or Miss Clifford, whatever her real name is, I think it's Miss Clifford, has acquired a decent amount of money through her professional endeavors. I don't know that. I don't know that at all. I would assume so, being a relatively famous adult film star. So, presumably she would be able to bear the cost of arbitration in the same way that, well, not in the same way that Trump would, but in a capable manner. It's not like she's homeless, right? Like that's the idea here. Mutual releases, except for the rights and obligations of the parties set forth in this agreement, DD for himself and each of his representatives, agents, signs, heirs, partners, companies, affiliated companies, employee, blah, 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 blah. Wow. Forever releases and discharges PP individually and all of PP's heirs, attorneys, and each of them of and from any and all claims, demands, damages, debts, liabilities, accountants, reckonings, obligations, costs, expenses, liens, actions, and causes of actions of every kind and nature whatsoever, whether known or unknown. So if Trump had some sort of claim against Daniels, Clifford, wow, never going to get used to saying Clifford, if he had a cause of action against Clifford for any of this stuff, then he would have to release her from that. He would not be able to bring suit. And then same thing with PP here. Releasing any lawsuit she would have against DD. Subject matter referred to in paragraph 6.1, 6.2 above are collectively referred to as the release matters. Parties hereto, each of them hereby warrant, represent, and agree that each of them is fully aware of the section 1542 of the Civil Code of the State of California, which provides as follows. General release does not extend to claims which the creditor does not know or suspect to exist in his favor at the time of executing the release, which, if known by him, must have materially affected the settlement with the debtor. The parties waive the provisions of 1542 and any other similar federal and state law as to any and all claims, demands, and causes of actions. So even if they don't know about it, they're waiving that. For avoidance of any doubt, by virtue of this settlement and this settlement agreement, the parties hereby waive any unknown claims against each other individually, and each of their representatives, agents, assigns heirs, partners, companies, affiliated companies, blah, 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 and so on, so forth. Confidentiality of this agreement. The parties respectively shall not to disclose the terms of this agreement either directly or indirectly to the media or anyone else other than their respective attorneys and representatives, and or as may be required by law. PP may not comment or make any press releases or otherwise discuss the resolution of the subject of this agreement. So this is interesting because this, I told you to have me look, or to help me look for this. This looks like it would bar Cohen from talking about it. Although Cohen technically isn't a party to the agreement, he is an attorney to the agreement. So that's a little weird. It's still weird that he would mention it, but this may be the out for Miss Clifford. This really might void the contract right here. And again, I did not fully read this on my first read through, so I'm just seeing this for the first time now, and this may be enough to get out of it. It may not. It's a little weird because, technically Cohen isn't a party to it, but he may be bound. Man, I don't know. It's it's a really tough question. This will be one, I think this is probably where the court is going to get the most hang up, is determining whether Cohen's acknowledgement of the agreement, if Cohen's acknowledgement of the agreement shall not disclose the terms of this agreement either directly or indirectly to the media or to anyone other than their respective attorneys and representatives, and or as may be required by law. Cohen's acknowledgement of this agreement might fall in that category, but it might not. It might not, because if the court determines that Cohen is not a party to the agreement, then he can't breach it. It might not, because it may have been determined, or it may be determined, that the initial disclosure of it to the media when they first brought it up and Cohen's confirmation of it is not a disclosure under the agreement, or that the disclosure provision was already voided by Miss Clifford or her associates' disclosure to the media. However, the media got a hold of this, if they can put that onto Miss Clifford, then it may not have been a violation for Mr. Cohen to disclose this. So that's a tough one. That's a tough one right there. I guess we'll see. Miscellaneous terms. This agreement constitutes the entire agreement. You can't bring in outside stuff. That's all this says. DD's election of either California, Nevada, or Arizona laws and venue. This agreement and any dispute or controversy relating to this agreement shall in all respects be construed, interpreted, enforced, and governed by laws of the state of California, Arizona, or Nevada at DD's election. Attorney fees in the case of a dispute. In any event of any dispute, action, proceeding, or controversy regarding the existence, validity, interpretation, performance, blah, 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 the prevailing party in any resulting arbitration proceeding and or court proceeding shall be entitled to recover as an element of such party's costs of suit and not as damages all attorney's fees, costs, and expenses incurred or sustained by such prevailing party in connection with such action, including without limitation legal fees and costs. Attorney fees and costs in formation of this agreement. Parties shall each bear their own costs, expert fees, attorney's fees, and other fees incurred in connection with the creation of the settlement agreement. Waivers and modifications. This agreement cannot be modified or changed except by written instrument signed by all parties hereto. No waiver of any of the provisions of this agreement shall be deemed to constitute a waiver of any other provision. Blah, blah, blah. Scope of provision, severability, and headings. So anything, the headings aren't actionable. Those are merely helpful guidelines. The severability is that if anything is found to be not workable or unconscionable, it should be severed, and the rest of the agreement should be preserved if possible. Advice of counsel, understanding of this binding agreement. Each of the parties represents that they have their own attorneys. They've had a chance to negotiate and review this document, and this is a final agreement, and it is binding upon them. Further execution. In order to carry out the terms and conditions of this agreement, PP agrees to promptly execute upon reasonable request any and all documents and instruments necessary to effectuate the terms of this agreement. And then any notice, demand, or request that one party desires or is required to give, including service of any subpoena to the other party, must be promptly communicated to the other party by using their respective contact information below by both email or facsimile and telephone. Either party may change his or her contact information by knowing the other party of said change pursuant to the applicable terms herein. So to DD is to Essential Consultants LLC, care of Michael Cohen Esquire, for Park Avenue. I don't know what that says. New York, 10022. Oh, 502 Park Avenue, number 10A. New York, 10022. And then to PP is care of Keith M. Davidson Esquire, 8383 Wilshire Boulevard, Suite 510, Beverly Hills, California. This agreement shall be executed with one or more separate counterparts, each which, when so executed, shall be deemed to be an original and together shall constitute and be one and the same instrument. So that's with the letter there. So here's the thing. Oh, and this is the other thing I told you guys to look out for. Any executed copies or signed counterparts of this agreement, the declaration, any other documentation may be executed by scanned, printed PDF copies of signatures and or facsimile signatures, which shall be deemed to have the same force and effect as if they were original signatures. In witness whereof by their signatures below, the parties have approved and executed this agreement as of the effective date first set forth herein. So, yes, PP has signed, EC has signed. It looks like Michael Cohen has signed on behalf of EC. Keith Davidson has signed validating the form for PP. Michael Cohen has signed as the attorney for EC LLC. Now here's the interesting part. No attorney has signed for DD, and DD did not sign. DD is not required to sign this document for it to have effect. Michael Cohen, acting on behalf of EC, should be sufficient. As stated above, either DD or EC or both can execute this document. But even if not, it is entirely possible that this is the signed executed copy that Miss Clifford has, and that Trump, if this is indeed Mr. Trump, that Trump would have his own signed copy, and that either of them, or they would then combine the documents, or he would have the fully signed and executed copy later, and that those two documents combined would manifest the agreement required. You don't necessarily have to have all the signatures on the same page for it to be valid. You just don't. And I feel like they mentioned that somewhere here. Maybe that's in the next document. I believe I read that somewhere. Okay, yeah. Here it is. This agreement may be executed with one or more separate counterparts, so copies, each of which, when so executed, shall be deemed to be an original, and together shall constitute and be one and the same instrument. So if there's a copy of this that Trump has signed and Trump's attorney has signed, then it is technically the same instrument. So there's that. That's why earlier I said, did he sign it? We don't actually know if he signed it. They're alleging and asserting that he has not, but he very well may have a signed copy sitting in a drawer. So Exhibit A to the confidential settlement and release, assignment of copyright and non-disparagement agreement, side letter agreement. So this is the parties. To whom it may concern. The side letter agreement is entered into by and on behalf of the parties with respect to the confidential settlement agreement and mutual release entered into by and between them on or about October 28th, 2016, in which Stephanie Gregory Clifford, a.k.a. Stormy Daniels, is referred to by the pseudonym Peggy Peterson, and blank is referred to by the pseudonym David Dennison. It is understood and agreed that the true name and identity of the person referred to as Peggy Peterson in this settlement agreement is Stephanie Gregory Clifford, a.k.a. Stormy Daniels, and that any reference or designation to Peggy Peterson shall be deemed the same thing as referring to Stephanie Gregory Clifford, a.k.a. Stormy Daniels, by her true name as identified herein. It is understood and agreed that the true name and identity of the person referred to as David Dennison in the settlement agreement is redacted, and that any reference or designation to David Dennison shall be deemed the same thing as referring to redacted by his true name as identified herein. It is understood and agreed that the true name and identity of the entity referred to as EC LLC in the settlement agreement is redacted LLC, and that any reference or designation to the EC LLC shall be deemed in the same thing as referring to redacted LLC by its true name as identified herein. It is further acknowledged and agreed by parties that notwithstanding the provisions of paragraph 7.1 of the settlement agreement, which provides that the settlement agreement constitutes the entire agreement between the parties with respect to the matters herein and supersedes all prior and contemporaneous oral and written agreements and discussions pertaining to the matters herein, this side letter agreement shall be deemed part of the agreement between the parties. Accordingly, paragraph 7.1 of the settlement agreement is hereby amended via supplanting to provide as follows. 8.11. Integration. The side letter agreement entered into by the parties concurrently with their entry into this agreement shall be deemed part of this agreement, and this agreement and the side letter agreement together constitute the entire agreement between the parties with respect to the matters herein and supersedes all prior and contemporaneous oral written agreements. For avoidance of doubt, it is further agreed that this side letter agreement shall constitute confidential information as defined in the settlement agreement, that neither this side letter agreement nor any portion hereof may be disclosed to anyone except as and to the extent expressly provided in the settlement agreement, and that any unauthorized disclosure or use of this side letter agreement or any portion hereof shall constitute a material breach of the confidentiality provisions of the settlement agreement. It is further agreed that neither party shall keep a copy of this document, and that only Keith M. Davidson, Esquire, and blank, counsel for the parties herein, we assume Michael Cohen, shall maintain possession of it or access to this side letter agreement For avoidance of doubt, the parties hereto agree and confirm that this side letter agreement is deemed attorney's eyes only. This side letter agreement may be executed in counterparts, and when each party has signed and delivered one such counterpart to the other party, each counterpart shall be deemed to be an original, and all counterparts taken together shall constitute one and the same agreement, which shall be binding and effective as to the parties. The agreement may be executed by facsimile or electronic PDF signatures, which shall have the same force and effect as if they were originals. By signing below, each of the parties signifies their agreement to the terms thereof. So here you have Stephanie Gregory and Keith Davidson, and then Michael Cohen signing, no David Dennison signing, and that, doesn't matter, because if there is another document out there with his signature on it, then this is also a valid agreement. So there you are. I know this is a long form process, but legal documents are long things with lots of language. The main thrust of this case is whether or not there is an agreement between Donald Trump as a person named David Dennison and or a company called Essential Consultants, LLC, and between one of those two or both of them combined and Stormy Daniels. Whether or not an agreement exists. If an agreement exists, then Stormy Daniels can't talk about it unless the court finds that it's void. And the court probably, if they determine that an agreement exists, would send it to arbitration, as the arbitration is likely binding. So there's that. Then at arbitration, and here's the reason that they're bringing this suit, because if it goes to arbitration, then Stormy Daniels likely breached the contract when it was initially leaked to the media and is liable for $1 million in damages. Liquidated damages under the terms of their agreement. She probably doesn't want to do that, and probably attorney's fees, for the arbitration as well, which will get pretty expensive. She doesn't want to do that. She definitely wants to avoid it. So another question will be: is Michael Cohen responsible for breaching the non-disclosure agreement by mentioning it to the media? And that's a really tough question. If you notice, I paused for a very long time in trying to figure out if he indeed breached the contract. And I don't know the answer to that question. Because if the court determines that the contract was already breached by Clifford in its initial leak to the media, then Cohen is not in breach. Because the terms have already been breached. And there's nothing preventing the Trump side of this agreement from talking in times of breach or alleged breach. There is a restriction on Miss Clifford speaking in times of breach or alleged breach. So it becomes a really, really kind of interesting question for the courts. But the long and short of all of this is that Trump loses by this thing being brought, whatever he's going to lose, because it doesn't matter what the truth is. It doesn't matter what the salacious stories are. We've all decided what those salacious stories are, whether they're lurid sexual encounters, whether it's some sort of violent encounter that resulted in physical injury to Miss Daniels, or perhaps there is a child of Donald Trump's out there somewhere that is being covered up by this, and that would be extremely unfortunate. But all of those stories are already circulating around in the minds of people, and the more and more publicity this gets, the more and more those stories will be created in their brains. And whatever the truth is will probably be somewhat underwhelming compared to what we've all imagined has happened at this point. So Trump loses on this issue, but the question will be, can he punish Miss Daniels for releasing any information? And that's interesting. And is Trump actually a party to any of this? You know, perhaps Cohen did all of this on his own through a dummy corporation without Trump's knowledge. And that is possible. And it's possible that that is a violation of Cohen's duties, but Maybe not. I don't know if Trump gave him authority to negotiate settlements, and gave him a specific dollar amount to stay under. Perhaps it's not a breach, although there could be some election law implications involved in the payment of $130,000 if it indeed came from Trump and not Cohen, or if Cohen was reimbursed for it. But, these are all interesting questions for the court. I hope you found this informational. I'm going to try and do a short summary video that will also have these points, and you're probably watching this video after that. So I apologize in advance if I'm able to get that thing recorded without hating it too much, for saying that I don't do those. I'm trying to do those more without tangenting off about legal topics. But the real question is whether or not this agreement that we have produced is real, is valid, and is binding. And that will be interesting for the court to decide. So thank you all for watching. Again, I hope this was informative. Check me out, patreon.com/lawsplaining. Drop some feedback in the comments, what you like, what you don't like. Is it too long? Is it too short? Do you want more information on these issues? If you have questions about anything that I didn't cover in the contract, drop them in the comments. I'd be happy to answer them. Hope you all have a good night. Peace.